How to fill out Texas Form VTR-262, Affidavit of Heirship for a motor vehicle. When a vehicle owner dies, transferring the title can feel like one more complicated task during an already difficult time. A small error, such as one wrong VIN digit, a missing heir, or a signature completed too early, can cause a county tax office to return the paperwork and delay the transfer. In this guide, we will walk through Texas Form VTR-262, the Affidavit of Heirship for a motor vehicle, one section at a time. You will learn when the form is appropriate, who must be listed, who must sign, what the notary completes, how to handle the odometer statement, and which supporting documents may be needed. Keep in mind that this is general information, not legal advice. Estate and heirship questions can become complex, and a local county tax assessor-collector makes the final decision on whether a title transfer package is complete. Also, before using remote online notarization, confirm that the receiving county office will accept a remotely notarized and electronically delivered document. Start by confirming that VTR 262 is the correct form for this state. According to the Texas Department of Motor Vehicles, this affidavit is generally used when a recorded vehicle owner has died. There has been no administration of the estate, and no administration is necessary. If the estate has been probated, the executor or administrator normally uses the authority provided by the court, such as certified letters testamentary or letters of administration, to transfer the title. In that situation, VTR 262 is generally not required. The form can also apply when a court has determined that no administration is necessary, but additional documents must be attached, including the original or a certified copy of the court document and the portions of the will that identify the decedent and the heirs. Before filling anything out, determine whether there was a will, whether probate or administration has been filed, and whether a court has issued an order. If you are uncertain, contact the county tax office or a qualified Texas attorney. Choosing the wrong procedure can create delays and may require a completely different set of documents. There are three main roles in this process. First are the heirs, who become affiants when they sign the sworn certification. They identify the surviving heirs, confirm the statement about the estate and the will, agree that the vehicle should be transferred, and sign under oath. Second is the transferee, the person or entity who will receive the vehicle. An heir may also be the transferee, but the roles are still distinct on the form. The transferee or title applicant is normally responsible for presenting the completed package to the county tax assessor-collector. Third are the notary and the county office. The notary verifies the identity of the appearing affiants, administers the oath, witnesses the signatures, and completes the notarial certificate. The notary does not decide who the legal heirs are and does not approve the title transfer. The county office reviews VTR 262 together with Form 130, title evidence, lien documents, insurance, and any other required records. One critical restriction is that the heir certification may not be completed through a power of attorney. The required affiants must personally make the sworn statement and sign before the notary. Before writing on the form, gather reliable records. For the vehicle, use the Texas title, registration receipt, or another official record to locate the complete vehicle identification number, year, make, body style, model, title or document number, and license plate information. For the deceased owner, confirm the exact name shown on the motor vehicle record, the date of death, and the county and state where the death occurred. Also determine whether a lien is still recorded. If the lien has been paid, you may need an original release of lien. Next, identify every person who must be treated as an heir for this procedure and collect each person's full legal name and current address. The official instructions explain some common family situations, but heirship can become legally complicated. If the decedent left neither a spouse nor children, or if relationships, adoptions, guardianships, or competing claims are unclear, get legal advice rather than guessing. Finally, decide exactly who will receive the vehicle and how that person or entity's name should appear. Doing this preparation first helps keep names and facts consistent across VTR 262, Form 130U, the title, identification, and supporting documents. At the top of page 1, complete the vehicle and decedent information section. The official instructions say all fields are required unless the form indicates otherwise. Enter the full VIN carefully. A VIN contains a mix of letters and numbers, so compare every character with a title or registration record. Then enter the year, make, body style, and model for the title or document number. The form specifically says to leave it blank if it is unknown. Add the license plate state and number if the vehicle has a plate. Next, enter the date of death and the location of death, meaning the county and state. Do not substitute the decedent's home county unless that is actually where the death occurred. In the recorded owner line, enter the first name, middle name, last name, and suffix exactly as they appear on the vehicle record. Pay special attention to initials, hyphenated names, and suffixes such as junior or senior. Before moving on, compare this section with the official documents one more time. Corrections can create extra work. The form warns that line-through corrections require a statement of fact, while erasures or significant alterations may require a new form. The next section lists the surviving heirs. One copy of VTR-262 provides space for as many as 3 heirs. For each heir, enter the full first, middle, and last name, any suffix, and a complete address with city, state, and zip code. The official information provides general signing rules. If one heir is a surviving spouse, that spouse may be the only heir required to complete the form, unless the decedent had surviving children whose other parent is not the surviving spouse. In that case, those surviving children must also participate. If there is no surviving spouse, all surviving children must sign as affiants. Children born to or legally adopted by the decedent qualify, and a guardian signing for a surviving minor child must attach letters of guardianship. If there are more than 3 heirs, complete additional copies. Additional copies are also needed when all heirs cannot appear before one notary on the same date. Then complete the transferee section with the person or entity receiving the vehicle and the complete address. Up to 2 transferees may be entered, and an heir may also be a transferee. Every completed copy must be submitted with the title application. The affiant certification is the sworn hard form. Complete the vehicle, decedent, heir, and transferee sections before signing the certification. Read the entire statement carefully. It says that the recorded owner died on the date and at the location listed above, identifies the affiants as the sole known heirs or beneficiaries covered by the procedure, and directs that title be issued to the named transferee. The form also warns that falsifying information is a third-degree felony. Select a statement that accurately describes a will. Either the decedent left no will, or a will exists but no application for administration or probate has been filed, or a court has determined that no administration is necessary under the conditions stated in the affidavit. Do not check a box merely because it seems easier. Each required heir must personally appear before a notary, take the oath, and sign. Every affiant signature must be notarized. Do not sign in advance. The official instructions also state that this section cannot be completed through a power of attorney. If more forms are needed for additional heirs or separate signing dates, make sure the vehicle, decedent, heir, transferee, and will information remains consistent on every copy. Directly below the heir signatures is a notarial certificate. Leave this part for the notary. The certificate states that the named heirs personally appeared, were duly sworn, and declare that the statements in the affidavit are true and correct. The notary completes the venue, including the state and county, signs and dates the certificate, and applies the official seal or stamp. Because this is a sworn affidavit, the notary must administer an oath or affirmation rather than merely watch an acknowledgement. Below that is the odometer disclosure statement. Federal and state law may require mileage disclosure when ownership transfers. If the vehicle is subject to disclosure, enter the odometer reading in whole miles without tenths. Check mileage exceeds mechanical limits, only when the odometer has rolled beyond what it can display. Check not actual mileage, only when the displayed mileage is not the vehicle's true mileage. That creates an odometer discrepancy warning. One seller, heir, or agent signs and dates the statement, and the transferee or agent signs and dates the acknowledgement. The instructions permit this odometer section to be completed after the notarization, and only one seller or heir is required to execute this separate mileage statement. Notarizing VTR-262 does not by itself transfer the vehicle. The title applicant must assemble and submit the complete package required by the county tax assessor-collector. TXDMV instructions identify Form 130, U, application for a Texas title and/or registration, and a completed VTR-262. Depending on the facts, the package may also include the existing title, an original lien release, out-of-state title or registration verification, current proof of liability insurance when applying for registration in court, or will documents when a court has determined that no administration is necessary. TXDMV's current guidance also notes that a gift affidavit may be required when a vehicle is inherited between eligible parties. So confirm that requirement with the county office. Ask the office about fees, payment methods, whether an appointment is needed, and whether it accepts remote online notarization and electronically delivered records. If accepted, Notary 20 offers a convenient remote option. Complete the form except for signatures and notarial fields. Submit the document. Join a live video session with valid identification. Take the oath and sign as directed. The price is only $20 per document. After notarization, review the completed file before submitting the whole package. Let's finish with a final review. First, confirm that VTR 262 is appropriate because the estate is not being administered, or because the relevant court procedure and documents allow this route. Verify the VIN vehicle description, recorded owner, date and location of death, every required heir, and the transferee. Check the correct statement about the will. Use additional copies when there are more than 3 heirs, or when the heirs cannot appear before the same notary on the same date. Do not pre-sign. Every required heir must take the oath and sign before a notary, and every affiant's signature must be notarized. Make sure the notary completes the certificate, date, venue, signature, and seal. Complete the odometer disclosure when required, and assemble Form 130U, title evidence, lien release, insurance, court documents, will pages, and any gift or out-of-state records that apply. Then submit every completed copy to the county tax assessor-collector. If your county accepts remote online notarization and electronic documents, visit notary20.com for a convenient session. Only $20 per document. Confirm acceptance first. Upload your unsigned form and let Notary 20 help you complete the notarization correctly. Thank you for watching.